Welcome to Team Tiggio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
Seated. Mr. Gretzky.
We're here in the case of State of Ohio versus Kenneth King, case number 25-CR1023. Defendant is present in the courtroom and represented by defense counsel Chad Mulkey. The defendant pled by way of information to attempted having weapons under disability of felony of the 4th degree, and we are here today for the sentencing.
Smokey.
Thank you, Your Honor. We are prepared to go forward. Thank you, Judge. Your Honor, we'd be asking the court for community control with no prison or jail time in this matter. Your Honor, he's led a relatively law-abiding life since 2002. He's under disability for a trafficking charge in 01, Your Honor. In the facts of this case, Your Honor, he went out, listened to some music in his car, fell asleep, inebriated. Gun happened to be in the vehicle. My understanding is he was cooperative with the police. When asked if if there was a firearm in the vehicle, he answered yeah. And the center counsel, Your Honor, he wasn't trying to cause any trouble. It was a premises check at his residence. He's currently on SSI income. He does not have a valid license. He is married. He's got some medical conditions, including some TIAs or mini strokes, Your Honor, so he would just like to be able to attend to his health. It's doubtful you'll see him in this or any other court again in the future. So again, taking that all in mind, there's no reason to believe he won't be successful on community control, abide by all the court's orders and follow all of probation department's rules. So for those reasons, Your Honor, we would be asking for community control with no additional jail time. Thank you.
All right, Mr. King, what do you want to tell me?
May I stand up?
You sit or stand, it doesn't matter.
I just wanted to say that day was an idiotic thing that I did. I wasn't thinking at the moment, but once the officer woke me up, I thanked the officer, for waking me up, because anything could have happened to me while I was asleep, That was an idiot. Oh boy, I feel like a real idiot right now. Being in your courtroom, and as far as the courts, I apologize for what I know I did. I take full responsibility. Full responsibility.
What are your mental health diagnoses?
Bipolar, schizophrenic.
Are you being treated for that?
Yes, I take medications. Being treated.
What medication do you take?
May I open?
Yeah.
Okay. What we call this? Pardon me. Amlodipine. It's some long words, but it's.
I can help, Judge, if you'd like. Or I can give the judge the document if you want.
Let me see.
Yeah.
What doctor do you go to?
Metro Health Dr. Mary Ryan.
How often do you go there?
Once a month.
For medication?
Medication, trying to stay on my forest while I gets up in the morning and basically dizzy. Got pills. I have medication for that also.
Your Honor, his next visit is Wednesday, October 8th at 1:40 p.m. at Metro Health Cleveland Heights.
Okay, then what's with the marijuana too?
I just smoke it just to eat. I don't go outside, period.
Right, but how does it affect your other medication?
None. The doctor even noticed. I mean, we can call her right now and she'll say, well, it was helping him eat.
How does it help you eat?
It helps me eat. It helps me eat a lot. Because my weight goes flush weight, ups and downs. I'm 142 now. Maybe, next week I might be 129. And it's been going on frequently.
What about these other health problems that you've had?
The hernias, I had 7 hernias, surgeries done. Carpal tunnel syndrome, both hands, my bones were deteriorating inside my hand. 1 lung, took it out left side, left underarm. One other, wait a minute.
What about these mini strokes that Mr. Mulkey said?
Oh, yes. Day comes and goes.
When's the last one you had?
Last one I had was, 3 months ago. During the summer? June, sometime May, June, something. Yeah, this is in that range.
Okay. All right, Ms. Zagretsky,
State recommends community control sanctions.
what does the community control officer have to say about that?
We are all for
Okay.
community control, Judge.
All right, I've reviewed the PSR and the drug and alcohol and listen to Mr. King, listen to counsel, considered all the applicable statutes. I'll put you on probation for a year, 3 days in jail with credit for 3, continue with your mental health treatment at Metro Health, and pay the cost and supervision fees. Anything else, Ms. Zagretsky?
No, Your Honor.
Mr. Mulkey?
Nothing further, Your Honor.
Okay. All right, we're adjourned.
We are set today for an intervention in lieu hearing. It's my understanding the defendant is going to withdraw his previously entered plea of not guilty and enter a guilty plea in case number 25 CR 816 to count 1, receiving stolen property, a felony of the 4th degree, and in case number 25 CR 818 enter a guilty plea to count 1, theft, a felony of the 5th degree, and count 2, breaking and entering, also a felony of the 5th degree. As previously stated, a motion for intervention in lieu has been filed in this case, and on the 816 case, the defendant has 126 days of credit, and on the 818 case, the defendant has 127 days of credit. Thank you.
Ms. Smith, you want to address the motion first?
Yes, Your Honor. We are asking the court to grant the motion and allow Mr. Cobb to complete the court's intervention in lieu of conviction program. Mr. Cobb is 18 years old, and he does have a lengthy misdemeanor history. However, he has no history of felony convictions. And, Your Honor, Mr. Cobb had a tumultuous upbringing as a child. He did live in JFS custody from the ages of 13 to 18 years old for all but 4 months, and during that 4 months, reunification with his mother was attempted. He was placed back in JFS custody because his mom was addicted to drugs. Throughout his childhood, Mr. Cobb's mother used drugs, his father was in prison, and he went from family member to family member until he ended up in agency custody without the example of what an adult is supposed to do in this world. Mr. Cobb, ILC will be an opportunity for Mr. Cobb to take control of his own life and create opportunities for himself as an adult that he did not have as a child. He has a number of mental health diagnoses and has had no treatment since 2021. Additionally, Your Honor, Mr. Cobb suffers from severe alcoholism and has been abusing drugs. He recognizes that he needs to take control of to get sober and take control of his mental health so that he can achieve employment stability, obtain stable housing, and create opportunities for himself moving forward in life that he didn't previously. Your Honor, Mr. Cobb is aware of the consequences should he fail, but should he succeed, I feel that in light of his history, he'll have earned the dismissal. And for those reasons, Your Honor, we're asking the court to allow Mr. Cobb to enter the court's intervention in lieu of conviction program.
Ms. Bell?
Thank you, Your Honor. The state had the opportunity to review the the intervention plan report, the pre-sentence report that was made in this case, and the state does not object to intervention in lieu. Thank you.
All right, I'll grant the request for intervention on both cases. So, Mr. Cobb, we're going to go through a series of questions which I ask you if you understand the rights that you have in both these cases, and if you're waiving those rights and entering pleas of guilty. Do you understand that?
Yes, sir.
How old are you?
18-year-old, sir.
How far did you go through school?
I graduated 12th grade.
Are you a U.S. citizen?
Yes, sir.
Are you able to read, write, and understand the English language?
Yes, sir.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No, sir.
Have you ever been diagnosed with or treated for any mental illness?
Yes, sir.
What have you been diagnosed with?
ADHD, ODD.
When do you take any medication for that?
No, not this current moment, sir.
All right. You able, with those conditions, are you able to understand what's going on here today?
Yes, sir.
In 25-8-16, did you get a copy of that indictment?
Yes, sir.
And in 25-8-18, did you get a copy of that indictment?
Yes, sir.
Do you understand the charges in this case?
Yes, sir.
All right. And you're pleading guilty to one count in the 8-16 and both counts in the 8-18 case, is that correct?
Yes, sir.
Okay, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you. And I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, or you want to talk some more to Ms. Smith, let me know and I'll give you more time. You understand that?
Yes, sir.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. You understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, sir.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes, sir.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, sir.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, sir.
Do you have any questions about any of your rights?
No, sir.
Do you still want to plead guilty in both these cases?
Yes, sir.
You understand you're fully admitting your guilt to the charges?
Yes, sir.
You understand by pleading guilty to these felonies that you're voluntarily giving up your freedom for whatever period of time I can sentence you to prison, to jail, or to community control.
Yes, sir.
In the 816 case, receiving stolen property is a felony of the 4th degree. It carries a maximum prison sentence of 18 months and a maximum fine of $5,000. Do you understand that?
Yes, sir.
In the 818 case, count 1, theft is a felony 5 with a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes, sir.
And count 2, breaking and entering, is a felony of the 5th degree with a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes, sir.
I could give you a consecutive sentence. That means one sentence after another for the separate offenses in 818 and for the separate cases in 818 and 816. Do you understand that?
Yes, sir.
If I gave you a consecutive sentence on all these charges together, you face a maximum prison term of 42 months and a maximum fine of $10,000. Do you understand that?
Yes, sir.
Any question about that?
No, sir.
You understand your felony conviction will prevent you from owning or possessing a firearm.
Yes, sir.
Do you understand that if a prison term is imposed in these cases, and upon your release, as part of your sentence, you might be placed on post-release control for up to 2 years under the parole authority?
Yes, sir.
If you were to be placed on post-release control and violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, sir.
If that violation were a new felony, then you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes, sir.
And if that were to happen, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes, sir.
Do you understand if a prison term is imposed, you are eligible for judicial release?
Yes, sir.
You could be placed on community control for up to 5 years, but if you violated any conditions, I could send you to prison for 42 months. You understand that?
Yes, sir.
Now, has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No, sir.
If you are sentenced in this case, did anybody promise you what I will sentence you to?
No, sir.
You understand that I would not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes, sir.
Have you had enough time to talk with Ms. Smith before pleading guilty today?
Yes, sir.
Has she discussed everything about your case and answered all of your questions?
Yes, sir.
Are you satisfied with the advice she has given you?
Yes, sir.
Have you been threatened or coerced in any way to plead guilty today?
No, sir.
Are you freely, knowingly, and voluntarily entering your guilty plea?
What was the question, sir?
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, sir.
Do you have any questions?
No, sir.
All right. Ms. Bell, if 816 went to trial, what would the evidence show?
Thank you, Your Honor. Had case number 25 CR 816 proceeded to trial, the state would have proven beyond a reasonable doubt that on March 19th, 2025, the defendant was knowingly in receipt of property, having reason to believe that property was stolen. Specifically, the Willowood police were dispatched to 417 East 307th Street for their report of a stolen vehicle. The police met with Mark Baudel, who stated his truck was stolen out of his driveway the night before. His keys were inside the vehicle, and the vehicle was recovered on March 20th, 2025, and processed by the Lake County Crime Lab. The Lake County Crime Lab found the fingerprints on a article or a bag of jerky found inside the vehicle, and the fingerprints belonged to the defendant, Devin Cobb. That truck was a Ram pickup truck bearing Ohio registration PND 8883.
Ms. Smith, anything to add to those facts?
Nothing to add, Your Honor.
All right. Mr. Cobb, did you understand what Ms. Bell said that the facts would show if 816 went to trial?
Yes, sir.
Are those facts true?
Yes, sir.
All right, what is your plea to receiving stolen property a felony for?
Oh, guilty.
All right, Ms. Bell, if 818 went to trial, what would the evidence show?
Thank you, Your Honor. Had 818 proceeded to trial, the state would have proven beyond a reasonable doubt that on or about April 15th, 2025, in Willoughby, Lake County, Ohio. The defendant, by stealth, did trespass in the Osborne Park Pool concession building, that being in an occupied structure, with the purpose to commit theft therein. While inside, he stole an HP gaming tower, it's a computer, and 1 Minute Maid canned beverage that belonged to the city of Willoughby. The defendant's DNA was located at that scene. That computer that I mentioned was worth more than $1,000, but less than $7,500.
All right, Mr. Cobb, did you hear what Ms. Smith, anything to add to those facts?
Nothing to add, Your Honor.
Mr. Cobb, did you hear what Ms. Bell said the facts would show if the case went to trial?
Yes, sir.
And are those facts true?
Yes, sir.
What is your plea to count 1, theft to felony 5?
Guilty, sir.
What is your plea to count 2, breaking and entering a felony 5?
Guilty.
Ms. Smith?
These are the same forms, so we don't over Sign here. You can stand if you need a better angle. Do the same thing. Your Honor, I have in my hand the written pleas of guilty for both cases, which I did have opportunity to review with my client prior to coming on the record. I answered all of his questions, and he indicated an understanding of the plea. I've witnessed him sign the written plea of guilty in open court, and I've done the same.
Your Honor, I would as the defendant sign both written pleas of guilty. Ms. Smith and I have signed the same.
All right, on the 816 case, Mr. Cobb, did you sign that written plea of guilty?
Yes, sir.
And do you want me to accept your written plea of guilty?
Yes, sir.
Accept the written plea of guilty on 818. Did you sign that written plea of guilty?
Yes, sir.
And do you want me to accept that written plea of guilty?
Yes, sir.
I'll accept the written pleas of guilty on both cases. Defendant was present with Ms. Smith. Advised of all of his rights, been a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequences of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, voluntary, will accept his plea of guilty in 816. Of receiving stolen property of felony 4, and in 818 of theft of felony 5, and breaking and entering a felony 5, I'll state of criminal proceedings. In both cases, and I'll place you on an intervention plan for a period of 5 years. You're going to serve on both cases. The plans will be the same with the exception of a jail credit. 180 days in jail with 126 days of credit for 816, 127 for 818. The last 30 days you'll be in the jail treatment program, complete it, and follow the recommendations. After that, you're going to go to NeoCap, complete that program, and follow the recommendations. You're to get a mental health evaluation and follow those recommendations. After you leave NeoCap for a minimum of 6 months, you're to go to live in a sober living facility. You're to have no drugs or alcohol, and you'll be screened. You're to go to only one doctor and one dentist and one pharmacy for any prescription medication. You're to take your medication only as is prescribed. And you will sign releases for probation to get on any records. You're to go to at least 4 AA meetings a week and get a sponsor. At the appropriate time, you're to obtain and maintain full employment. And you pay the costs and supervision fees. Any other terms, Ms. Crook?
No, thank you, Your Honor.
Okay, Mr. Cobb, do you understand the terms?
Yes, sir.
Any question about the terms?
Yes, sir. When you need 180 days, well, I got a credit for 180 days.
What?
So how long would I be in the jail from now?
You're going to be in there for about 54 more days. The last 30 days, you're going to be in the jail treatment program.
Yes, sir.
Any other questions?
No, sir.
All right, if you violate the terms, then the state will file a motion to terminate the intervention plan. If I find you violated and I terminate it, then you'll be convicted of 2 felonies in the 818 case and 1 felony in the 816 case. Do you understand that?
Yes, sir.
And then you'll be subject to all the penalties that we talked about during the questioning. Do you understand that?
Yes, sir.
All right. Now, Ms. Smith has filed this motion for intervention, and I granted it because you got a whole bunch of stuff in a short period of time with an upbringing that was irresponsible on the part of your parents. And this is the attempt to get that straightened out and get you in the right direction. Do you understand that?
Yes, sir.
And that's up to you to accomplish that. Anything else, Ms. Bell?
Nothing further, Your Honor. Thank you.
Ms. Smith?
Not this time around.
All right, we're adjourned.
All right.